Hi, I'm Florida Foreclosure Defense Lawyer Michael Wasylik. I'm here in Brooksville, Florida at the Hernando County Courthouse, and I'm here today for summary judgment hearings. So I wanted to take just a minute and talk about what it means to have a summary judgment hearing in your foreclosure case. Now, a summary judgment hearing is a final disposition, meaning that if the motion is granted, the bank gets a final judgment, a sale date, and an auction will be held, and the home will be sold, and you'll be asked to leave. But it's not automatic, because a summary judgment hearing, the purpose of a summary judgment hearing, is to resolve a pure question of law, just simply a legal question only, when the facts are not in dispute. So if there's any kind of dispute of fact, the summary judgment should be denied. So I'll give you an example. In many cases, the bank will submit an affidavit, a sworn statement under oath, which says that the borrower defaulted, here are the amounts due and owing, and there's no question as to the bank's standing to proceed. And if there's no opposition from the borrower, then the foreclosure judgment is generally going to be entered. The affidavit alone can sometimes serve to show that there's no facts in dispute, or if in other types of civil cases you might have admissions by one party or another, or there's a deposition where the other side is given testimony that you can use, or in some cases the parties may agree the facts are what they are and the only question that they want the court to resolve is a question of law. Now, in a foreclosure case, usually there's some kind of dispute as to whether or not there is payment, default, there's disputes over standing, there's all kinds of facts that should be in dispute, and any dispute over a fact that matters, a material fact, should be enough for the court to deny a summary judgment. Now, the way that a defense lawyer or a borrower who's defending themselves would prove that is by doing a couple different things. One is they would submit an affidavit of their own saying, here are the facts that I dispute. The bank says this is true, I say this is true. We have conflicting affidavits. That's a push. That means the summary judgment should be denied because there's a reasonable chance that there's a fact in dispute. So that should be denied. Now, the other way to do that is by saying, well, for example, when I have a case, I often will take a deposition of the bank, and the bank representative will show up. They'll answer questions that I ask, and the answers to those questions will demonstrate that there is some kind of uncertainty as to the facts of the case. So, for example, I may ask at deposition the bank witness, how do you know that you're the right bank to be foreclosing in this case? And very often they won't be able to answer me, or they'll give me answers that conflict with some of the things that they've said in their papers or elsewhere. And then I can go to the court and say, well, Judge, they're saying this thing here and this other thing here, those things don't line up, therefore there's some kind of question as to the facts of the case, summary judgment should be denied, and then the case should proceed to trial, where the trial court, the trier of fact, can weigh the evidence and decide how to resolve those questions of fact. So generally speaking, when you've got a summary judgment, most judges know that those should almost never be granted if there's any kind of hint of a dispute of fact. In fact, the legal standard is beyond the slightest doubt. That's higher than in a criminal case. And so if there's any kind of doubt as to a material fact, as to one that matters for the outcome of the case, the summary judgment should be denied. So if you're facing summary judgment, know that you have to either be prepared to assert that for yourself or have good counsel who is able to find out what those disputes of fact might be and able to present that to a court in a way that will prevent summary judgment from being entered. Now, defendants can also move for summary judgment in certain circumstances, and I'm not going to get into that today, but just know that summary judgment is a tool that cuts both ways. You can either get a case, a judgment granted for plaintiff or a judgment granted for defendant. And a lot of times I will ask for summary judgment on defendant's behalf. That's a powerful tool for defendants. So if you're in foreclosure, you think you might have a summary judgment hearing coming up, or you might want to try a summary judgment of your own, you have questions about a foreclosure, give us a call. We offer a 30-minute free consultation. My number is 352-567-3173. That's 352-567-3173. I'm Florida Foreclosure Defense Lawyer Michael Wasylik. Thanks for taking the time to watch the video.